Hi there, I'm James Dafferty, and this is Coffee and a Case Note. Given the opportunity, I'd speak to you guys about Section 232 of the Corporations Act all day because it's such a fun area, corporate oppression. Today's case, we're talking about oppression within oppression. So the plaintiff side, the people who've kicked off the proceedings, they are shareholders in 6.275% of a company. The defendants include the shareholders of 70% in the company and some other defendants as well, including the company, right? So if we think back broadly to what we're talking about with corporate oppression, we're talking about commercial unfairness. So our plaintiffs kick off a big piece of litigation to say these various transactions in relation to the company are unfair. And so pursuant to Section 233 of the Corporations Act, there should be some orders for relief made. Our shares should be sold at a certain price, or the company should be wound up, something like that. Not super relevant today, but I just want you to hold on to that big oppression background, right? So there's this big oppression fight going on. And as the litigation's rolling along, it comes to light that the company, who is only one of the defendants, is actually paying the legal fees of the other defendants as well. And so what our plaintiffs say is, this is also oppressive. And so within the large set of oppression proceedings, we also kick off an interlocutory application, a pre-final hearing application for an immediate injunction preventing the company from paying the legal fees. Does that make sense? So we've got our poor old plaintiffs with no money. Then we've got our defendants who are having their serious legal bills paid by the company. Does that make sense? There's sort of an air of unfairness about this. So the plaintiffs say, we are making, not only do we have a big application on, but we're also making an urgent application right now to stop the company paying those legal fees. Right. So the plaintiffs approach the court, and in order to get interlocutory injunctive relief of this kind, you need to satisfy the court that the balance of convenience is met. So firstly, in order to meet that test, the plaintiffs needed to prove that they had a pretty good argument if the matter went to final hearing. And the court said, essentially, yeah, look, there's a pretty good argument that having the company pay the legal fees of other parties could well be oppressive. Then the plaintiffs needed to convince the court that damages were not enough. That makes sense? The plaintiffs need to say to the court, this breach is so serious, we are put to such a disadvantage that mere damages at the end of the litigation is not going to be good enough to help us. We need injunctive relief right now. What the court said in short was, no. It said, while you may have a pretty good argument that causing the company to pay the legal fees is oppressive, you haven't convinced the court that damages at the end, perhaps just some arithmetical exercise whereby the amount of legal fees paid by the company is part of the calculation for how much the successful plaintiffs might have their shares bought for, is not enough. So we have a big oppression suit where there's possibilities for success. We have a little oppression suit within it where there was a possibility for success, but sadly, in this case, the plaintiffs, well, sadly or happily, I guess, depending on your point of view, the plaintiffs didn't get up on that interlocutory application. They were unable to prove that damages were not enough. So they were unable to pass that balance of convenience test. So hopefully a quick little sketch of returning to Section 232 of the Corporations Act, a bit of oppression and a bit of chit chat about an interlocutory injunction was of value to you guys. I look forward to having another chat, another coffee and another case note with you soon.